although it was filed this morning, Mr. Stevens, Mr. Spencer, Mr. Valenzuela, are you able or ready to respond to that motion?
Yes, good afternoon, Judge. Joe Spencer, Mark Stevens, and Felix Valenzuela for the defendant. We are ready to respond to that.
And I'm asking for announcements of counsel at this time.
Good afternoon, Your Honor. Bill Hicks, John Hicks, and Rebecca Tarongo on behalf of the State of Texas District Attorney's Office. We are present and ready to proceed on our motions.
Good afternoon, Judge. Christina Sanchez, El Paso County Attorney, here with Ian Kaplan, Assistant County Attorney.
Stay up. You're going to be the first
All
one.
right, ready.
I'm going to
Okay.
get you in. I'm going
Yes,
to get
sir.
you out of here.
Thank you.
I am in receipt of your non-party county attorney's motion for an in-camera inspection of U-put of work product materials. Have you brought the items for my in-camera inspection?
Yes, sir, we have brought the items, and Judge, I just wanted to make a couple of acknowledgments for the record. One, we know that we do have consensus, at least from the defense team per their motion, as I understand as well from a conversation this morning, as well as from the district attorney's office with regards to the in-camera inspection, and of course the county attorney's office as well. Judge, just for the record and for some argument's sake, I understand that the defense team had put forward a response to our motion for the in-camera inspection. I would like to acknowledge, and for this court to acknowledge, that although their motions, I think, are similar in nature in terms of why we are here and putting forth the information for this court to consider, I would make the argument, Your Honor, that the breadth and scope that the defense team has argued in terms of what is applicable as attorney work product is a little bit more than what we would argue is the case for this particular
Well, I agree.
matter.
I think they're in agreement with you turning it over.
That's correct.
As I read more of it, I think they're trying to give the court the education that they see
That's
that
correct.
the court may need, and you're going to give me the education that you believe
Yes.
the court needs.
Yes, sir. And so just for purposes of further cases and, of course, the unique position that the county attorney's office is in right now, we had, as we know, a civil removal proceeding involving the former district attorney, Ivan Rosales. And as a part of that hearing and of that motion and those arguments, the county attorney's office collected, as part of its investigation, work product. That consisted of emails, that consisted of notes, that consisted, quite frankly, of trial strategy and impressions, settlement negotiations as we proceeded along through the civil removal proceeding, that in our perception and in our argument would say that that is not necessarily discoverable in this matter. In addition to that information, we also had collected as part of our investigation additional information that did not have anything to do with this particular case. It was in other matters that were part of our civil removal proceeding against Ms. Rosales at the time. And so just wanted to make that argument there in terms of the material that's there. What we would propose, Your Honor, and I do have the records here today, all of the 160 pages plus approximately that we had referenced in our motion. What I would argue, Judge, of course, if this court would like, we can turn over the unredacted copies. But what I would like to propose, Judge, if we can have the opportunity to not redact, but highlight those provisions or those portions of our attorney work product where we think goes to the trial strategy, which we would argue goes to other arguments that have nothing to do with this case. Again, highlighted, we're not redacting it so that the court could see all of the information that's in there and then make the decision.
You're highlighting what, if you would be in the chambers with me for an in-camera inspection, would be your argument that this is work product.
That is correct, Your Honor.
Does either side have an objection to our county attorney's proposal?
No objection from the district attorney's office.
Your Honor, on behalf of the defendant, the county attorney has filed actually a very proper motion with the correct law stated. So we have no objections to the course in which the county attorney wishes to proceed because they have captured the essence and the spirit of what they're trying to do correctly.
And if I remember correctly from the September 12th hearing, one of the things that the defense is asking for is any investigation by either the district attorney's office or any other agency that may have done that. Do you have two copies with one being highlighted, or you have one copy that you'd like to highlight?
One copy that we would like to go through that exercise of highlighting. Yes, sir.
Let's do that. Let's
Okay.
go ahead and give you that opportunity. Can you get it to me by the end of the day?
Can you give us at least till tomorrow, Judge?
Not a problem. Can
If we
you
could
get
do
it to
that.
me before the end of the morning tomorrow?
We will try our best, Your Honor. Yes, we will. Okay. And if I could just make one more argument for the record?
Absolutely.
One more argument, and just because of the unprecedented nature that the county attorney's office had handled the civil remover proceeding, we do argue and would say that there is no specific law on point that provides that there is an extension, and to say that all of the material, especially work product, we understand the sensitivity to that, in a civil proceeding would always have to be turned over to the defense in any and all criminal proceedings. I want to make that clear, that because of the unprecedented nature of where we are today, I don't want that impression to be taken away with. There is no case law on point. There is a Texas Attorney General opinion that discusses it, but it only discusses it as it pertained to a county attorney's office that handled both civil and criminal prosecutions, not in this case where you have two different prosecutorial offices. So wanted to make sure that we're not establishing a precedent on that, sir. Thank
Yes,
you.
ma'am. Any input from either side at this point before I ask the county attorney if they want to stay through this or if they want to run away? Anybody else has anything to say on this matter?
Nothing further on this particular issue, Judge.
Your Honor, the only thing I would say on this issue is that we're not gonna be privy to see the portions, excuse me, that the county attorney is highlighting as what they claim is work product. I'd like to remind the court that, work product does not trump Brady, any Brady or due process obligations that the state of Texas has.
Yes, I understand that. Thank you.
Thank you.
Do you want to stay?
May we be excused, Your Honor?
Run as fast as you can.
We have a lot of other work. Thank you.
I know you do, that's why I'm letting you leave. We are here next on the state's motion to unseal all non-ackie ex parte motions, orders, and contents. Mr. Davis, you may proceed with your motion.
Thank you, Your Honor. Counsel. Your Honor, first of all, thank you for granting a hearing on the motion, and I will try to briefly summarize our position, because I know we've extensively set it out in our various pleadings. We do rely, of course, on the motion that you just called, our objections we filed today, and our written motion for continuance that we have filed. Your Honor, the situation that the state sees today and the problem before the court is just, it's essentially preserving our adversarial system of adjudication, which is what I think all of us learned in law school, and which we were about, that if you're going to present something to a court, you ought to have the other party there and have it heard and just flesh it all out in an adversarial system. You know, I think what the default understanding that all of us have as lawyers is that parties, you know, should not communicate with the trial court regarding pending matters before the court without the presence of all parties and a full and fair hearing. The problem that we ran across in answering the defense motion set for next week was that about midway through, there was discovered by us for the first time that there were possibly ex parte, could be hearings, but at least orders, that that were not what we would call ACI orders, what we call ACI versus Oklahoma orders, allowing for the appointment of experts through ex parte proceedings. That's the one exception that in criminal law that we have, really the only exception to having full and fair hearings. You can have an ex parte appointment of an expert, and I think you can pay that expert under that also and do that ex parte. But that's our one established exception in 1985 in the Court of Criminal Appeals in the Williams case I've cited, blessed it in the early 1990s and said we could do the same thing. But outside of that, we found that there had been orders by just the defense admission, because we thought, nothing that turned us on to there being possibly some ex parte orders that were outside of AKI until you got to the motion. And I want to go ahead and introduce a certified copy. I've shown this to defense counsel already. States Exhibit 1, which is their, I'm going to call it motion for discovery and sanctions. It's got a very long title, and I would seek to introduce that as States Exhibit 1.
No objection, Judge. These are court records.
States Exhibit 1, for the purpose of this hearing only, is admitted into evidence.
Thank you, Your Honor. So, what we had then was, on page 33 of that exhibit, that motion, was a footnote by counsel for the defense saying ex parte orders were entered on 2 different dates, and it had to deal with spoliation of evidence, of not, I guess, turning over all the surveillance tapes of the defendant. That's not an appointment of an expert. That's seeking for the sheriff's office to turn over tapes that they think would have some evidence in them. And
Turn
the other
over
one
tapes?
had to do
Hold
with
on, Mr. Davis.
some ex parte
Mr.
order.
Davis. Mr.
At least we
Davis,
believe it's an ex parte order.
you said turn over tapes. Wasn't it more preserve tapes?
I think it was preserve and turnover.
Okay, go on.
But either way, Your Honor, either preserve or either way would still not be an AKI order.
Okay.
I'm sorry I didn't catch you. And the other one is on page 32, which talks about an order that was entered to prevent mental health professionals from seeing the defendant. Not an appointment of an expert on their behalf, but to block mental health experts from seeing the defendant. So we had those 3 orders that tipped us off that there was some non-AKI ex parte orders that were being entered. So that is what prompted us to, and me especially, to start looking at the docket sheets and seeing that there are perhaps hundreds of ex parte orders that have been entered. And since we have 3 that we know are not AKI, we'll be requesting the court to look at all those and unseal whatever is not AKI orders, and to allow us to see those and see what we can do to answer the allegations in their motions and maybe some further motions. In that regard, I also have some of these to the defense. These are the docket sheets in both cause numbers. This cause number 2019 0D04878 before it was re-indicted. That's States Exhibit 2, and then States Exhibit 3 would be the docket sheet in the current cause number 2020 0D02631, showing as, and for the purpose being, showing the entry of orders sealing record throughout the, extensively throughout the second cause number, and I think there's just, I don't know, 9, 10, 13, something like that in the first cause number. And that's the 2 docket sheets, States Exhibit 2 and States Exhibit 3.
No objection, Your Honor.
States Exhibits 2 and 3 for the purpose of this hearing only are admitted into evidence.
So, Your Honor, and to answer the defense response that the case of In re City of Lubbock, which in that case the court I won't go into it too much, but basically an ex parte order to the City of Lubbock Police Department to turn over records ex parte. And the Court of Criminal Appeals took great pains to say, no, we don't operate ex parte in criminal cases in the state of Texas. The only exception being Akey, a very narrow exception. They took the Amarillo Court of Appeals, who first had a look at the at the mandamus to task, saying no, there's no widely accepted practice in Texas criminal cases of allowing ex parte orders. The only widely accepted practice is if you're doing so under Akey, to ask for an expert ex parte. So there's no new law here that's just suddenly found. For decades and decades, I think when all of us, I know I'm probably the oldest one going to law school here, that we all were taught you don't do that. And then Akey came along in 1985 and said, okay, we're going to let you do this in this one area. And there's no inherent trial court authority to do otherwise, and there's no, I don't want to disclose my defense strategy that lets you do otherwise. You have to have express constitutional or statutory authorization to have ex parte orders, and the only thing that's been recognized is Akey. So, I think, Your Honor, with all that being said, this is an easily correctable situation. I think this court can go and look at review the orders that have been sealed by this court, and look at all of them, and any of those that are ex parte, non-Akey orders to unseal hearings, motions, orders, contents, whatever the contents that were sealed under that, because all of those orders are void. Under In re City of Lubbock cited in our motions, all of those orders are void. And we're not at a point in the proceedings where that's not a bad deal. We're not in trial. We're not even really into the contested hearings in this matter that the court has set for next year. So I think the court can go in, easily correct this at this point. So as a State's Exhibit 4, which I can't mark or anything else, but as a State's Exhibit 4, I would like to have the court include, as part of this hearing, a part of this record today, all of the sealed orders that we have in the two cause numbers that you see in the two docket sheets. Include those sealed orders as part of the record, and go in to all of those, have them all come up from the clerk's office, a copy of those, and for the court itself to go through it, determine what is not Akey and was an ex parte, non-Akey order of some kind, and unseal all of those, and perhaps in an order that those are void and no longer viable. The other thing I want to say about the reason that we should go ahead and not say that these are only after In re City of Lubbock was decided, and that it's only should not be retroactively applied, is that if whatever ex parte non-Akey orders there are, whatever there are, those are continuing violations this day. So prospectively, today, those void orders are still an ongoing violation. So even prospectively, they're still being carried into effect. And the state is entitled to have those declared void and unsealed. And so I don't think that the argument that only the non-Akey ex parte orders that occurred after the decision in re City of Lubbock came out should be the ones that the courts consider. We want the court to go back through both docket sheets and look at all those and have those included in this record as State's Exhibit 4. Again, since they're sealed and I can't get them at this point, I can't bring the court a physical exhibit up here that I know of to introduce into evidence, but I would like a ruling on that too, Your Honor, and see if that's an acceptable procedure for the court to initiate and go through.
I'm going to deny your State's Exhibit 4. At some point, all of these sealed documents are going to be unsealed, whether it's today or at the conclusion of this case, and everybody will know that they went from being sealed to unsealed. And so, do me a favor, Mr. Davis, give States 1, 2, and 3 to my bailiff so that he can get them to me. Is
All
there
right.
anything further with regard to your argument at this point?
I need to make one further statement, Your Honor.
Yes, sir.
Make sure I get all the case summary. There's that one. Here you go. This one too. Thank you. All right, Your Honor, then the only other thing that I have is that under Rule 103 of the Rules of Evidence, I'm making an offer of proof of my State's Exhibit 4, which would be all of the sealed orders shown in State's Exhibit 2 and 3. And the reason I want those introduced into evidence is what I've stated. We have at least 3 orders that we know are ex parte non-achy orders from the State's Exhibit 1, and would like all of those as far as not only the orders but motions, hearing, attachments, any of the contents that were sealed, to be a part of that and to come up for the reason that it violates NRA City of Lubbock and the cases I've stated in our objections and in our motion, and that they're void because of NRA City of Lubbock. There's not a retroactivity problem because it's an ongoing violation which will continue today and in the future, and I do make that offer of proof under Rule 103. Thank you, Your Honor.
Hold on, Mr. Davis. Isn't States Exhibit 2 and 3, isn't that exactly what it is? An offer of proof as to the sealed documents?
Well, it's actually proof of showing that there are that many sealed documents, and then I want the actual documents.
I know what you
orders.
want.
That's my offer of proof under State's Exhibit 4.
Well, so basically you want States Exhibits 2 and 3 to be an offer of proof as to your States Exhibit 4,
Well,
because I'm not giving you access to the sealed documents.
it's actually just demonstrative of what State's Exhibit 4 is,
Right,
and shows that.
yeah. And for appellate purposes,